Our next case this morning is in re Holbrook. Good morning, council. This is a 15-minute mini oral argument on the application. It's my understanding that you'll be splitting time, 7.5 minutes.
That is correct,
That's
Your Honor.
correct.
Per the court's request, I'll be splitting my argument with the guardian ad litem.
Okay. And will you be reserving time for rebuttal?
Just ever so briefly, I think
Okay.
this case is not.
Since you're sharing time, I just ask that you're both cognizant of that, that the clock runs for the total. Okay, great, thank you. And you have 2 minutes of a free fire zone, or you may waive that if you wish.
Thank you, Your Honor. Good morning to this most honorable court. My name is Cecilia Carandango. I represent the respondent mother, who's also the appellant in this case. There were 3 issues that were briefed before this court. They all basically revolve around the same case, which is in Ray Huckett, which was previously decided. The first issue revolves around whether the Court of Appeals, and before that the trial court, erred in finding jurisdiction under MCL 712A.2B1, which basically says that a parent, when able to, refuses or fails to provide proper care for their child. In this particular case, the minor child presented with what, in my experience at least, is one of the most severe cases of mental health issues. The child was both suicidal and homicidal. The mother made arrangements for him to be in an inpatient treatment facility. The young man went to Havenwick Hospital, where he participated in inpatient programming. Havenwick then made a decision that he was good to be discharged to another residential facility, which the one that was selected was Safe House. This facility is a specialized facility that provides a very high level of mental health care for minors. The minor child was placed there, and after some time, he was not discharged because he had completed the services, but he was basically discharged or thrown out of there because his behaviors were too severe for this particular facility to handle. At that time, what happened is mother expressed, and DHHS was already involved with the family. She expressed her desire for the child to go back to Havenwick Hospital, which was a facility that was able to address this young man's severe needs. DHHS wanted mom to sign community mental health paperwork for him to be assessed for home-based services, which, to be quite frank with this court, was asinine at best. It was very clear that there was no way that this child would be able to function at home. Mother had, but she did sign the paperwork. Subsequently, there was basically a refusal to transport the child back to Havenwick, and mom was told at some point she just needed to put him in an ambulance and take him there herself, which was unsafe. The court found jurisdiction basically stating that the child needed services. Although mother had done everything that she could, the child needed services, and therefore she was going to take jurisdiction. The case that the Court of Appeals relied on when we appealed the court's finding was in Ray Huckett. And one of the questions from this court was whether it applied to that case. The Huckett case was also one of mental illness, but it was also one of homelessness. And in that particular case, the child in Huckett presented with mental illness, but was then deemed appropriate for discharge, having completed inpatient services. And at that time, the mother had been evicted from her home and was finding herself homeless. So those were the facts that presented in the Huckett case. And the court, I believe, probably held that jurisdiction could be exercised because the mother did, in fact, not have anywhere to take the child. So it's different. So I believe based on that, based on the fact that basically the situation that was created in our case was created because DHHS maybe saw things differently than mom. But mom didn't fail to provide proper care and custody for her child. She had a plan in place.
When we're talking about homelessness, wasn't the child homeless when Safe House would no longer keep the child and mom refused to have him returned during that period of time?
Yes, so I know that that's what the guardian ad litem is, and that was what the guardian ad litem argued at trial as well, was that the child basically was constructively homeless because Safe House was his place, and when he was basically evicted from there, and the mom couldn't take him home because it was unsafe, it rendered him homeless. You know, I disagree with that. I disagree with that because the child was not homeless. The child resided. So I think there's also a difference between when we're talking about the dependent. I guess I'll just jump to the third issue. When we talk about the dependent, whether a child is a dependent, there has to be several findings. And one of them is that, you know, either the home environment is creating a situation, but he wasn't homeless. He was still domiciled with his mom. He was residing in a facility which was Safe House, but he wasn't domiciled there. He was still domiciled with his mom. And she did have a home for him. The problem in this particular case is that, no, he couldn't go home to his mom. But the mom still had a place which she, as the custodial parent, could make those decisions for him. And that decision was to go back to Havenwick Hospital, which I think was within her full, you know, I guess, parental authority to make that decision in conjunction with DHHS. The problem in our particular case, in my opinion, is that DHHS put barriers in place for mom in order for her to be able to have the child safely returned to Havenwick. They basically told her that they weren't arranging for transportation and that she could arrange for her own transportation, which was also unsafe. The child clearly needed to be in an inpatient mental health facility. So to say that he was homeless because he was so severe that he needed to be in an inpatient mental health institution, I think it's a dangerous kind of slippery slope situation, because then what do we do with children that are in long-term medical facilities? Are they now not, you know, domiciled with their parents anymore? Did the parents somehow lose, you know, control over them because they're there? What if they're in
That's a different
school?
situation though, because it's not just their placement in a residential facility. It's once that placement is terminated for any reason, if they don't have some place to go back to. And you're making a distinction between mom not having a place for the child to return to and mom refusing to have the child return there.
Not necessarily, because I think she had a different plan for him. Her plan was for him to go back to Havenwick, which is where he went after he was removed from the mom. And he could have went there too, or he could have gone there under her supervision too, as he was before he went to Safe House. He wasn't removed from her when he went to, when he stayed at Havenwick the first time.
What if Havenwick hadn't taken him back?
Then she could have taken him to Common Ground in Pontiac, which would have assessed his needs. You know, there's other facilities.
So as long as he ended up at some facility, the fact that mom was refusing for him to return home did not create a situation where he was homeless?
I believe so, because I think mom has the authority to provide for whatever, you know, setting it is, unless it's not safe, of course. But her, you know, as the parent, her decision was that her child needed an inpatient facility. And so I think if the child had been refused at Havenwick, let's say, Common Ground, you know, is where you take the child for them to get assessed for whatever services they need. And she could have taken, you know, now this is all hypothetical, of course, but
Did the court need to have jurisdiction in order for him to go to Havenwick, or if they refused to go to Common Ground? I mean, did there have to be some basis of jurisdiction for that all to happen?
There was no jurisdiction when the minor child was there the first time.
Okay.
So he was there, you know, the mom had made that decision. He did stay there, and Havenwick decided, you know, that he had had enough treatment for him to go somewhere else. Then he went to Safe House. Those things were all done without court jurisdiction.
Okay.
So no, There was some talk about, and I didn't do the trial, so I was appointed to mom after the trial, but there was some talk about there were insurance issues, insurance wouldn't cover it. But mom is adamant that that's not true. You know, that really the real problem was that they asked her to transport him himself, wouldn't provide any assistance with that, which I think DHHS has an obligation to provide reasonable efforts before they just say, you know what, we're done with you and we're going to file a petition now. So there were other, and they didn't do that.
We're under 6 minutes, and I would like to hear from the GAL.
Yes,
Okay,
sorry.
but before
See,
you,
now I talk too much.
before you go, I want to ask about mootness. Why isn't this case moot? The trial court terminated jurisdiction and it's dismissed the case. And so, I know there's this issue of the registry. We don't know if your client's on the registry or not. Is that, first of all, is that your only argument that the case isn't moot, is the registry?
No, so I think the children's law section provided a very eloquent brief. They briefed it very, very eloquently for this court. And so today,
Let me ask you this.
I don't know, my client has had an extraordinarily hard time, herself getting documents to show if she was put on the registry. She was given notices that
She also has a statutory path to coming off the registry, right? She can very likely be expunged. Has she pursued that?
She submitted, so.
The statute, are you familiar with MCL 722.627?
She tried to request the documents showing if she was placed on the central registry to begin with, and has been unable to get confirmation on whether she's on there or not. Part of the problem,
Do you think she has a right to be expunged if she was put on there?
I think she has a right to be expunged.
Let me ask you, because we're running out of time, and I don't mean to cut you off,
No,
but
you're fine.
I just want to cut to the chase. If we find that the case is moot, which frankly I think it's looking a lot like a moot case, and then we were to decide further under our authorities that the lower court opinion should be vacated, why wouldn't that be a satisfactory outcome for your client? In other words, would you object to that? If the lower court orders are vacated, Court of Appeals opinion, the trial court order asserting jurisdiction, if those orders were vacated under a finding of mootness, wouldn't that solve this entire dispute in a way that's favorable to all parties involved?
If the orders were vacated, yes, it would satisfy everyone, I believe, because those orders would no longer be in place, and the idea would be that they would have been erroneous findings. I would agree with that. I don't know, and that would be up to this court, I guess.
No,
but
we
I
have
don't
a
know how to do
particular,
that
we have a
under mootness.
particular methodology, which I don't know that the parties have gotten into, for determining whether a lower court opinion should be vacated upon a finding of mootness. I'm just asking you, if we were to reach that conclusion, would your client be left with any objection at all? From my vantage point, I don't see one. I just wanted to hear from you on that.
The problem is that, so if the order vacates the findings of the lower court, so both of the Court of Appeals and the trial court, then I believe that mom gets what she wants, which is that those orders are, they're not orders anymore.
So beyond just potentially being on the central registry, it also eliminates some of the concerns about collateral consequences like a birth match or.
I think it would, because those are all real, and that was what I wanted to, both for
And
employment
if
purposes.
just to flesh this out further, if we were to reverse, to affirm, I take it back, reverse and remand to the Court of Appeals or to the trial court for further proceedings, then you'd have to go back and argue about this expungement or the registry issue. Is that?
I also don't know what further proceedings there would be, because if the findings were erroneous, let's say, then the case should go away, and she completed all the services, and there's no open case as to.
I know there's no case there, that sort of feeds into the mootness
But the
conclusion.
problem is all of the collateral consequences that are potential for her, and that's what I'm concerned about, and I think the children's law section laid it out very well.
All right, thank you, counsel.
Yep.
Give me a sign from heaven that we're on the right track on this mootness.
Good morning. May it please this honorable court and panel, I'm John Giancotti, I'm the lawyer guardian ad litem on this case. I see I have 1:45 left on my clock here. I'm not going to regurgitate all the facts. I guess I'd like to at least address the last question that Justice Viviano was addressing to the mother's attorney. If this case was reversed and it all went away, what would happen at the moment when the child was left at safe house is children in the future would suffer harm of essentially being homeless, which goes back to one of the questions that was already asked, because at that moment, that child couldn't go home to his mother, and he had been released from the program. He wasn't discharged because he had completed and he was ready to go home. It wasn't a discharge from the hospital, you're all better, go home. It was a discharge that this kid has really got some serious issues that we can't even handle, so you have to find another solution for. So I don't know that that is a practical resolution.
Isn't that something that should be addressed by the legislature? I mean, aren't we trying to put a square peg in a round hole by using this statute, which it looks at really the fault and neglect of the parents for a situation where I think it appears to a lot of us that the mother was not at fault. She was doing everything she could do, but was not able. So in other words, this statute doesn't really fit this circumstance. Shouldn't we go across the mall here and ask the legislature, you know what, we need to figure out something in our mental health code to deal with this circumstance?
I'm not going to disagree with that statement that the legislature has to address the mental health circumstances for children, but under these circumstances, if we take that approach, these children are going to be left with nothing. They're going to be on their own, and the purpose of the child protection is to keep families and children safe when things aren't safe for them. And as the GAL, I don't know what more the mother could have done at that point. So if there was no jurisdiction, it would have been mom's problem to handle, because we had, someone said earlier this morning, be careful what you wish for, and we had off the record discussions. If the court would have went in that direction, mom would have said, that child would have been, while the case was, because the child was in Havenwick at this point, and if the
Seemed like the trial judge did what good trial judges do when the statute doesn't work exactly right. She found a way to try to make it work in this circumstance.
that would appear to be the case, yes.
The problem is on appeal, and it happens a lot in family law cases where we try to make clear rules of law, it doesn't work as well because it's equitable and fact-specific and so on and so forth. And so that's sort of the point. It's hard for us to fix the statute here by stretching it to fix this problem when this doesn't appear to be a problem that the legislature contemplated when they enacted the statute.
Yeah, that could be the case, but it was my position that the child was technically homeless at that moment, and I believe that that's why I think the dependency statute could have provided the same services for a child or a family in those circumstances where you're trying to do everything within your powers to keep your children safe, your family safe, and have a healthy home. And there's no options out there, just like when there are children that are human trafficked under the dependency statute, there is relief there. And mental health is a problem that exists for our families and our society and children. And I do believe that under the dependency statute, it could be interpreted that this child was constructively homeless, which was.
And counsel, it is your position that the court getting jurisdiction was required to take action?
We needed jurisdiction, yes, in order for this child to remain safe and get the services that he needed.
There was no way for DHHS to help with the transport without having jurisdiction?
Well, I came in after all that because all the stuff that the safe house and the original Havenwick to the safe house was all before the case was filed. The case was filed when he was released from safe house and he had nowhere to go because he was stuck, so that's why they filed the petition.
Thank you.
So I know my time is up.
We encroached on your time, so if you have anything else to add, please go ahead.
Just on the mootness issue, I don't believe this is moot. I believe there's a public issue here. I guess if you took the approach that you could reverse and vacate the adjudication, then I guess that would could in part address it, but I still believe that the public issue for the well-being of children and the safety of families is at stake here, and there needs to be a solution in that regard. But I do believe in this instance, this child is constructively homeless. I guess that's my primary point.
Thank you.
Thank you.
Good morning, Your Honors, and may it please the Court. Joseph Shada on behalf of Petitioner, Department of Health and Human Services. Your Honors, this case is moot. The trial court has terminated jurisdiction. Respondent mother does not own any court costs, and notably, she is not on the central registry. No matter whether this court denies leave, affirms...
You haven't waived your time, but how do we know she's not on the registry? That seems to be a debated point, and it's apparently confidential, and
Yes,
why don't
Your
we
Honor.
know that for sure? 3
points in response to that. And when I inherited this case after the briefing was done, I spoke with the caseworker at DHHS. She specifically searched the registry and informed me that respondent mother is not on it. Second, one of the arguments that the LGL put forth in the briefing as to why respondent mother might be on the registry is because these registry reform amendments did not go into effect until after the inception of this case. However, if one were to go to the Department of Health and Human Services website, they have a section dedicated to information about the central registry. And in this section, they have a subsection specifically devoted to the central registry reform, and they have published a document that is titled Central Registry Reform Frequently Asked Questions. And in that they state, I quote, "The law is retroactive for all prior investigations. This means any case prior to November 1, 2022, which was the effective date for those amendments, that resulted in central registry placement but no longer meets the criteria due to the new laws would be expunged from the central registry."
The department, that's a policy decision by the department.
Yes.
So they could change their position on that.
They could, but DHS, their public position on their website published is that it is retroactive and that they have removed all the prior individuals placed on there who no longer meet the new criteria.
If you were mom in this situation and you're hearing this information for the first time here at oral arguments, you may be a little skeptical if you don't have anything in writing confirming all of these things. And this is just one piece, right? The central registry is just one of the arguments that was made. There's other things that come into play here with what happened at the trial court. But, you know, hearing this for the first time here, you know, may cause someone to say, you know, I hope that's true, but, you know, I haven't been told that. I have no confirmation of that.
Certainly, Your Honor. And 2 points in response to that. One, if this court has any question about whether respondent mother is or is not on the registry, this court always has the ability to retain jurisdiction, remand to the trial court, testimony can be taken on the matter, and the trial court could make a factual finding as to whether respondent mother is on the registry. In addition, there is a statutory procedure which respondent mother can simply request a central registry clearance from the department. I am unaware of any attempts that she has made to get this clearance form, and as
Justice Viviano had asked about that, and I think that it's good that we have that process, but should we require that for people that shouldn't be on the registry to begin with?
In this particular case, I think the best route would be to remand, retain jurisdiction, let the trial court sort it out, and go from there. With that...
That seems a little inconsistent with your view that the case is moot.
Well,
So let me just ask you, let me cut to the chase. If we agree with you that the case is moot, do you have a position on vacatur?
No. The petitioner would leave it to the discretion of this court and frankly has no objection if this court vacated not only the Court of Appeals opinion, but the lower court judgment.
If we found that was appropriate, would that take care of all of the collateral consequences?
I think it would, Your Honor, assuming that she is not on the registry.
But even if she is, once she shows up with our order vacating the lower court's order, wouldn't that eliminate the basis for her placement on the registry? I'm just trying to understand, if we're sympathetic to this woman, and I think most people involved in this case seem to be, if we issue an order of mootness and vacatur, the case is over and everybody goes home happy, and if we do anything else, people have to continue working on this case, and I'm just wondering why we would want that if we think that
I would agree.
Everybody's gotten what they wanted. It's a very strange case. People, you offer everybody everything they want, and they say no.
But should we also be concerned with, you know, I suspect, sadly, that this mom and this child are not unicorns. right? And so I mean, that they're not unique in that this situation happens, and somebody who hasn't, does everybody then have to get their case all the way up to the Supreme Court for us to vacate it and things to go away? Or is there a need to say that these orders you shouldn't adjudge a parent neglectful in situations such as this, which I don't think are one-offs, sadly?
Well, unfortunately, given that this is not unique, that is all the more reason why this issue is not likely to evade review in a future case. And in that future case, where the parties have that vested stake and a vested interest, and the answer to the question would have a practical legal effect on the particular case.
Do you think trial courts would benefit or welcome guidance from us about whether or not this is a proper route to take?
I think it would, but I think that should be done in the case where it has a practical legal effect. And unfortunately, since this is not a unique situation, that case will likely come in the future. And although this case is moot, I do want to briefly address the jurisdictional statute, just in case any of the members of this court get beyond the mootness issue. And MCL 712A.2B1 has 4 discrete parts to it. 2 of those parts make no mention of neglect, the parent refusing to do anything, any inaction or action by the parent. They simply focus on the juvenile. And those 2 parts are, first, whether the juvenile was at a substantial risk of harm to their mental well-being, and second, whether the juvenile was without proper custody. These 2 portions don't look to the parent's actions. There's no indication of fault. And although the trial court relied solely on the first portion of Section 2B1, which does have that neglect or refuses to act language, it made this analysis a little bit more complicated than it needed to be. In this case, it is undisputed that Safe House was inadequate to meet the mental health needs of this minor child. He needed a higher level of care, thus him being left at Safe House meant he was without proper custody. He couldn't just be left there, something needed to be done. And it is even more clear that jurisdiction was proper under this basis. And the trial court did not need to get into whether respondent mother was at fault or was not at fault. As this court has previously explained, the purpose of child protective proceedings are for the protection of the child. It is not to punish the parent. It is not to adjudicate guilt or innocence of the parent. It is simply the protection of the child. And it is without question in this case that the child needed protection, most notably from himself. And culpability on behalf of the parent was not and is not a prerequisite for intervention. And these are exactly the types of arguments that should be made in a case and can be made in a case where the parties have that vested stake, the vested interest, and the answer will have a practical effect on the outcome. Unless this court has any further questions, petitioner respectfully requests.
I have
Sure.
one more follow-up. So DHHS had to step in here in order to get this child back into services at Havenwick?
The testimony below was that a petition was necessary for these services. In addition, the order to take into custody was necessary for the department to be able to transport this child from Safe House to Havenwick.
Okay, in all situations, that's the case?
The way the testimony came out, it seemed to indicate that the department needs an order to take into custody in order to be able to transport any minor
So it's just the
child.
transportation, it's not getting the kid into a residential facility?
Well, the further testimony was that the petition, filing of the petition, was necessary to offer these services and to engage with the reasonable.
And I may have this wrong, but my understanding is that they required mom to sign the CMH paperwork in order to receive services. And then she was required to pursue all and exhaust all in-home treatment options before inpatient services were to be used. Is that required by statute? How does that work?
So unfortunately, the record, this is one of the spots in which this record is a little bit conflicting. So there was testimony that Wolverine was an inpatient facility, but that the minor child could not go here to Wolverine, which was inpatient, because that CMH paperwork was not complete. And that was the first witness, Ms. Saba, on page 15, testified to that. And she also later on testified that it was not her expectation that respondent mother take the minor child back into the home. The expectation was that somebody was to go retrieve the child from safe house to transport to Havenwick. But unfortunately, respondent mother was not able to do so. And granted, she had some legitimate reasons for not being able to do so, but somebody needed to do this transportation, and DHHS could not do so unless that petition was filed and getting that subsequent.
And I'm just asking, where's the authority for that? Is that statute? Is it policy?
I think it might be internal with DHHS, but I'm not positive on that, Your
Okay.
Honor.
And then just thinking about what we're talking about here, setting aside, mom and child that are involved in this case, thinking about the bigger picture, and I think kind of in line with what Justice Viviano was asking, is this a situation that maybe doesn't fit in the framework that we currently have with abuse, neglect, and child welfare? Should we have a separate section so that when you're talking about truly protecting the child, and in this instance from themselves or from hurting other people, that we're not going to have those collateral consequences to a parent that is doing everything that they can and saying, I need help here, where they aren't at risk of going on the central registry, or they aren't at risk for other things impacting them because of this situation.
Yes, Your Honor. I certainly think there could be a better alternative put into place by the legislature, and frankly, hope that they do so.
Okay, thank you very much.
Thank you, Your Honor.
Any other questions?
No, thanks.
Okay.
Thank you.
Thank you both. The case will be submitted.